to be an Indian patent agent. So, coming to the first topic, Manya, please, the next slide. Yeah. So, what is the objective of patent? I will mention the relevant sections from the patent law wherever it is required, and only few important sections. So, the first one we are going to deal with is Section 83 of the Indian Patents Act 1970. Is there any disturbance? Yeah. Okay. So, Section 83 tells us why are patents granted in India? What is the reason behind patents? That we can say that what is the objective behind patents? The first one is to encourage innovations. Let's take an example. If a person is coming up with some invention, now, because of the patent system in India, the whole setup, we are acknowledging the invention that yes, that person has come up with an invention and we should call it an invention. This is something new that he has done. So, we are acknowledging that. Also, we are giving some monetary benefits that we will discuss how monetary benefits are given to that person. Also, we are giving him credit that yes, the patent has been registered in his name, he is getting all the benefits, everything. So, that is how it will be encouraged. The whole concept of innovation, the whole process of innovation will be increased, it will be speeded up. So, to encourage innovations, not only that person will be encouraged to come up with more innovations, but also others in the society. So the first objective behind whole patent system is to encourage innovations. The next is to ensure that patents are worked in India on a commercial scale. If we read more about patents, we'll come to know that this is all about working. Because if we go, I'm sure you must have attended the copyright session. So in copyright, as we have seen that, okay, I have copyrighted something, I have registered something in my name. That's fine. I don't have to do anything with that after that. But in patents, if you have a patent registered in your name, it is essential that you work on that patent, you work on that technology, you come up with the product or the process you have registered. So that is how, if something new has come in the industry, it has to be worked. You cannot block that. Okay, I have invented something, now I have registered it in my name. Because it is registered in my name, no other person can use it, and also I'm not also using it. So that's how it will be blocked. That is not allowed in patent system according to the patent law of India. How that is again a very detailed topic, that you have to tell them the working statement, you have to continuously file a working statement how your patent has been working or not. And if the authorities come to know that yes, you have blocked the patent, you are not working on it, then also they can give compulsory license to someone else. So that is entirely a different topic. But as of now, we should know that the whole patent system, it ensures that the patent is worked in India on a commercial scale and that it is not blocked. So another object from this point we can derive is that we should get new technologies in the industries. So the next objective is to facilitate the disclosure of invention to the public while enabling disclosure. So whenever a patent application is filed, you need to disclose it to the public. So a specification, we'll come to that also, that how a patent application is filed. But as of now, I'll tell you that when you come up with an invention and you need to file it, so there is a detailed description which is um, drafted by the patent attorney on behalf of the applicant. In the detailed description, all the details related to the invention are included. That if a person reading that disclosure, if a person has an idea about the invention and he reads that disclosure, he can make that invention himself, or he can understand what all is there, how that invention is working. So a complete disclosure is provided to the public. Enabling disclosure means that once you go through that invention, then you can come to the invention directly. You get to know what the invention is exactly. That is enabling disclosure. So it needs to be disclosed to the public, so that once your tenure is completed, that 20 years is completed, then it comes in the public domain, so that the public can use openly and a new invention is given to the public. This is also an objective. The next is not as a tool for the patentee to enjoy monopoly as the exclusive importer of the patented goods. So, because in the patents, it's not only the right to import the patented goods, but you need to manufacture it. You need to sell it, export it, mm, all the things. So it's not the right to import, but yes, to manufacture and to exclude others from doing that or on working that invention. So these are the basic objectives of patents. So why we have such an established patent system in India? It is because of all these objectives behind the concept. I hope this is clear now. So we'll move on to the next topic. Next slide, please. Yeah. So what is a patent office? Patent office within the Indian government structure, we'll see that it comes within the Ministry of Commerce and Industry. And in this ministry, there are certain departments. So the department which deals with the patent system is Department DIPP, we'll call it, Department of Industrial Policy and Promotion. So in this DIPP, in consultation with three other ministries, which is Agriculture, HRD, and Science and Technology, they all work on the patents, the topic of patents, so this subject. Now, under this ministry, this patent office comes, and we have one office of the Controller of Patents, Designs, and Trademarks. Presently, we have four patent offices across the country. These are in Delhi, Mumbai, Kolkata, and Chennai. So, depending on they have certain territories divided between themselves. So, depending on the workplace or maybe the residence or of the person who is filing the patent, so that person accordingly chooses which patent office he needs to proceed to. So, this is how the patent office works. Next slide, please. Okay, so now we'll come to the concept of patents. Now, we'll take an example that if you are an inventor of a Tesla car technology, which is undisclosed, as of now, we'll suppose that this technology is not disclosed to the public. So you have come up with that invention and you wish to sell it in India. Now, first myth is that you cannot sell it, or you cannot make that basic product, the product basically. So you cannot manufacture that car if you have not patented it. No, this is not true. You can obviously do that. So this is a myth. Now we'll understand why we can do it. And if we can do it, what is the need of patent there? So obviously, if I have the invention, I'm manufacturing that product, let's say that car. But if I don't have the patent, anyone else can also produce that car and sell it. And I have no right to stop him from doing that. And because I have invested a lot of energy, lot of money, lot of time in coming up with that invention to come up to that. So despite all that investment, if I cannot stop anyone else from manufacturing that car or from using my own invention. So it will be a waste of time, waste of energy, and waste of other resources. That is why it is always advisable to go for a protection in patents, to protect it once and then sell it. So the first question is, what are you going to do? I hope by now it is clear that what should be the strategy of the person who wants to sell this car in India, right? The next is, why a patent and not any other IP? So for this, you need to have a basic understanding of all the IPs, that what all area do they deal with, what area is concerned with patents. Patents is basically related to science and technology. It's related to um, technological developments, basically, just like copyright is related to aesthetic, we'll say aesthetic contents, developments, just like that trademark is related to commerce, business. So for that you need to have a basic understanding, and then only you can choose that which IP is going to help you out, which IP you are going to resort to. So this is why a patent and not any other IP. And next is use or exclude. So we just now discussed it, that a patent is not a license to make, use, or sell an invention. It does not give the patentee the right to practice his or invention. As I mentioned, that if I have my invention, I can obviously practice it. I can obviously use it. No one can stop me from that if that is mine. But if I want to stop others from using my invention, then I need to go for patent protection. So we have discussed this, that the most common misconception concerning patents is that a patent gives one the right to practice his or invention. In fact, the patent merely grants the patentee the right to exclude others from practicing the invention. The inventor's right to practice his or invention is independent of the patent. So I hope this is clear now. So by now, we have understood that what is the concept of patents and why we should go for it and when we should go for it, right? The next slide, please. This is the basis of examination. So as we said that patentability criterias. So these are the three broad criterias that when you file a patent application with all the disclosure, as I mentioned, that you need to explain your invention in the detailed manner, as detailed as possible. You need to send it to the patent office, and then the patent office examines your application. And these are the examination criterias, the basic criterias. Three basic criterias are there: novelty, inventive step, and industrial applicability, so capable of industrial application. These are the three criterias that the patent office considers, the examiner considers, and then accordingly gives you a report that if it qualifies this criteria or not, qualifies this one or not. Accordingly, a report is given to the applicant. Now we'll come to the first criteria, novelty. The next slide. Yes. So the relevant section which deals with novelty is section 2J. So it should be 21J. Yeah. It defines invention, that invention means any new product or process involving an inventive step and capable of industrial application. In a layman's language, by novelty, we can understand that novelty means new. So the thing should be new. If you are coming up with an invention, it should be new. Now, whether it be a new product or a new process. Now, by new, what we mean is new invention means any invention or technology which has not been anticipated by publication. So it has never been published. in any of the publication. You cannot find it anywhere in any document. So it has not been published. It has not been used in the country or elsewhere. So it has never been used in the world before the date of filing of patent application with complete specification. So if I am filing an application on 1st of December 2022, let's say, and if that has somehow been published in any of the journal on 25th of November, so then we'll say that it is not at all novel because it is not new. It has already been published. Also, if it has been used, so you say that it has worked. Some experiments were performed, or some. Just a second, please. Yeah, so if some experiments were performed or some public displays were there regarding the invention before the date of my filing. So, in that sense, we would say that the invention is not new. The technology is not new, and it is not at all qualifying the criteria of novelty. Standard of novelty is absolute novelty. So, we cannot argue that partly it has been disclosed, partly it has been undisclosed, but it should be absolutely novel. However, there are different standards in case of oppositions, infringements, revocation proceedings. So all these proceedings, for that we need to understand the subject in detail. For opposition, because opposition is filed either before your patent is granted or after your patent is granted. So if one has A has filed an application and B is of the feeling that this should not be granted because it lacks some criteria, maybe it lacks novelty, so he needs to oppose it. He needs to explain why it is not novel. For that, he needs to file an opposition and start opposition proceedings. And there are two kinds of opposition proceedings. One we can initiate before it has been granted, before the patent has been granted. The other proceedings are which can be initiated after the patent has been granted. So I'm just giving you a brief, introduction about all these terms, so that whenever these terms are there, you get an idea that what is opposition, what is infringement. Infringement is there is already a patent, and then you come up with an invention, and the patent holder is of the feeling that your invention is infringing that particular patent. He feels that somehow you are using his already registered invention. Then he can initiate infringement proceedings. The other is revocation proceedings. So, revocation is once the patent has been granted. So, there are certain grounds on which revocation proceedings can be initiated. The next slide, please. So, by now we know that what is novel? Novel means new. New means it should not be published and it should not have been used before the date of your filing. That is novel. Now, how to determine if it is novel or not? Because the tests are not that simple. New invention means any invention or technology which has not been anticipated by publication in any document in the country or elsewhere before the date of filing of the patent application that we have discussed. That is, the subject has not fallen in public domain, or that it does not form a part of the state of the art. State of the art means the art which is already available. that the invention which is available to the public at present, that is called as state of the art, so which is already available. So it should not be in public domain, and also it should not form a part of the state of the art. It should not have been um, published in part also, because we said it should be absolutely novel. The next slide, please. So these are all the elements that destroy novelty. The first one we already discussed, prior publication. So if it has been published prior to your date of filing, then it is not novel. Also, this prior, as I have highlighted this word prior because it is very, very, very important. If you have filed the application of 1st of December 2022 and someone else has published it, or maybe you have also published it on 5th of December. Okay, just take this example and try to understand the chronology. On 1st of December, the application is filed. On 5th of December, it is published. Not your application is published, but some journal publishes the same subject matter. On 5th of December, that is published. Now, your application is examined the next year in December 2023. Fine. Now, in December 2023, the examiner needs to know if it is novel, right? Now, the examiner will consider all the documents or all the uses that have been made before your date of filing. So, the publication which was made on 5th of December will not be considered, and your invention will be considered as novel. Fine. That is why we have used the word prior, and this prior is very, very important, that it should be a prior publication prior to your date of filing. The next is prior claiming. Prior claiming means it has been claimed, or it has claimed means it is a part of a patent application. Because in patent application, there are certain titles, or there are certain topics which we need to mention in the application. And the most important one is the claim part. Claim. So, first in the application, you explain everything that, okay, this is my invention. I mix A with B, and then I treat B, and then I fix B somewhere, and this is how I come up with the invention finally. This is the description part. And the last part is the claim part. So, in claim part, you need to tell the examiner that I want protection, or I want claim only on these certain features, only on these certain points. Fine. Because maybe when you are claiming a car, let's say a Tesla car. So in car, everything cannot be new, right? A car needs to have some basic functions, some basic features, which every car has in the world. In the world, every car has some basic features. It has a steering, it has a gearbox. Some features must be there in every car. So I cannot claim the whole car, but I need to identify what new I am doing in that. And then I will let the examiner know that, okay, only this is the new part, and I want to claim this part. That will form a part of the claim. So now, coming to this novelty destroying elements, it is saying that prior claiming. Prior claiming means no one else should have claimed that portion that you are claiming right now, and also before the date of your filing. So this is prior claiming. Then is prior public use. We have already discussed that it should not have been used in public before. Next is prior public knowledge, because some things are there that Also, you see that they have not been published, they have not been used, but that is known to public. There are things that are known to public. So, and also before the date of your filing. So that is prior public knowledge. All these four elements, what they do is they destroy the novelty. So if any of these elements can be established by the examiner, it can be said that your invention is not novel. Fine. Proceed to the next one. The next slide. Yeah. So elements we have discussed. Now is the process of assessing novelty. It is a two-step process. The first step is to identify the relevant pieces of prior art for the invention in question. Now, the prior art means art. Art means what is available, which is a part of the knowledge right now. Prior means prior to your date of filing. So, all the documents which are published or which are available before your date of filing and which are related to the field of invention you are working on, all these documents are identified. Next step, it is assessed if the invention has been anticipated by any of these documents. So, um, you can see that example also if this is visible. See this example A. First document discloses a car. This is A. Next is autopilot disclosed in B. Now, the combination says this technology, autopilot car. We can say that A plus B is this invention. Fine. So, the first step was to identify A and B from all the literature available in the database. The first step would be to get A and to get B. The second step would be to see if this A plus B is new in view of A and in view of B. Fine. The next step, please. Next slide. So now we see that A. First document discloses a car. The second document discloses a autopilot, an autopilot, right? And this car is A plus B. But we are saying that yes, it is novel. Why so? We'll discuss. Please switch to the next slide. Because we see that for assessing novelty, the just give me. Yes. So assessing novelty, the examination bar is basically strict. So when we are assessing novelty and we have identified A and B, first we will consider A and we'll see if in view of A, our invention is novel. A was a car and R was an autopilot car. So if someone had seen A plus B was something which is new, right? Now leave A. Consider B. B is an autopilot plane. But an autopilot plane is different from an autopilot car. So then also our car is new. For novelty, there is a difference we need to understand. Actually, I was planning not to tell you before coming to the inventive step, but yes, it is crucial that you know it by now. So while assessing novelty, though we have identified all the relevant documents, but we cannot combine them. For novelty, we cannot say that A plus B is equal to our invention and so our invention is not new. We need to see A and our invention and then B and our invention. Fine. So documents cannot be combined for assessing novelty. However, in inventive step, we can combine the documents. I'll discuss it. So a book describing the invention put amongst the shelves of a public library but never taken down by anyone for a read is a relevant piece of prior art, because we say that you can see something is published. It is a less known book in a library which has never been read by anyone, but still, because it has been published, that can form a part of prior art for the invention. That is why we say that anticipation is strict, even if it is in a language which is very rare. And so we can say that many people would not have read that book and would not have come to the invention, but still it will be a part of the prior art. It will be considered while examining the present invention. Fine. The next slide. So I think the novelty concept is understood by now. Am I right? I have seen the chats also. So is this novelty concept clear now? Or else you can we can take up questions after the session. Fine. Now coming to the next one, non-obviousness. We can also call it inventive step or non-obviousness. It's one and the same. That's how we use it in the practice. Fine. So inventive step or non-obviousness. It is defined at 21JA. Inventive step means a feature of an invention that involves technical advancement as compared to the existing knowledge, or having economic significance, or both, and that makes the invention not obvious to a person skilled in the art. Okay, making it very simple, not going by the language. It's just that I wanted to discuss the section with you because you should be familiar with these terms also. Now, making it simple, for the inventive step, now documents should be considered. We found A and B. Now we can combine A and B. And for inventive step, a hypothetical situation is created. Like it is seen from the eyes of a person skilled in the art. Skilled in the art means he should have a basic understanding of that subject matter. If I am coming from a mechanical field, or I'm an automobile engineer, or I work in automobile, or I am a research student in the field, I can be said that okay, I have a basic knowledge of the field. So from my eyes, it will be seen. So document A and document B. First, it will be seen that okay, document A and B are combined. Then what is the result? If still there is something new in the invention, and that new invention has a technical advancement or advantage. Shreya, we can take up the question after the session if that is fine. And that new feature has a technical advantage which it gives to the invention. So then we can say that okay, it has an inventive concept. I'll take a more simple example. So there is a cradle, and a wooden cradle, and let's create a hypothetical situation that no one has ever seen a cradle painted yellow. Fine. So I have never seen a cradle painted yellow. Now someone has made a cradle and painted it yellow. Can we say that it is novel? For novelty, what we have to see, it should not have been published, it should not have been used, it should not have been known to the public. Fine. If we assess novelty, I can say yes, it is novel. Because yes, it is not available as a prior art. Fine. Now, coming to the next step, which is non obviousness or inventive step. Now, what we have to see is okay, we say that it is new, but for a person skilled in the art, is it non obvious? Can anyone tell me in the chat box so quickly? A cradle painted yellow, we have found out that it is novel, but for inventive step, we are saying that for a person skilled in the art, wouldn't have it been so obvious that okay, we can paint it in any color? Yes, it is obvious. Fine. So that how we'll say that it is novel, but it is not inventive. Fine, because it is obvious. Now, in the same example, let's say that because it has been painted yellow, let's say because of that paint or some different kind of paint, it becomes invisible in daytime. I'm saying that it becomes invisible in daytime. So now this feature, the new feature is obviously the paint only, but that paint, that paint has given a technical advancement to that device. Okay, technical advancement is it becomes invisible during daytime. So there is something added to that device. And this addition would not have been obvious to a person skilled in the art. Can we say that? Now we'll say that it has an inventive concept or it involves an inventive step. Fine. I hope with this simple example, the concept of novelty and inventive step is clear. The next slide, please. So, coming to that Tesla again, assessment or inventive step. A is first document discloses a car. B is autopilot disclosed. We have this invention, autopilot car. Now, person skilled in the art will combine A and B because I said that it should be seen from the eyes of a person skilled in the art. Now, one of the steps should be to assess if a person who deals in cars will be able to use a technology which is related to um, airplanes or not. Fine. So this should always sorry. So this should always be a question that if a person who deals in car, why would he go to something? Why would he refer to something which is related to aeroplanes? Fine. Person skilled in the art will combine A and B, hence not inventive because this is both of them they're related to the same field, transportation. So obviously a person can do so. So that's why we are saying that it is not inventive. But I'll take another example. This is actually a real case again, just like that cradle. This is also a real case. There was, yeah, the first time um, a person claimed for a laptop, what would you say, hinges, the way we fold the laptop, right? So the first time it was claimed, the examination, the examiner cited a prior art. Sorry. Okay. So we are discussing that laptop. The way we fold the laptop, there is some connection, like a mechanical hinge or some connection is there when we fold it. So the first time it was sent for granting, the examiner cited that this hinge is somehow similar to the hinge which is used in gates. doors. Fine. So the hinge is somehow similar, it is used in a similar way, and so this does not involve an inventive step. Now, what the argument was put forward, and also the argument was accepted by the patent office. The argument was that laptop, the field of laptop and the field related to doors is entirely different. So a person skilled in the art, skilled in the field of computers or laptops, why would he refer to something which is related to doors? If you have to see this from the person skilled in the art, then he is dealing with laptops. He will never refer to some document which is related to door. He will never get any suggestion from the field of doors. That's why he cannot combine these two documents. And when they cannot be combined, then you cannot say that it does not involve an inventive step. And the argument was accepted. So the field of invention is of great importance while assessing the inventive step. Am I clear? The next slide, please. Okay. So why are novelty and inventive step two different requirements of patentability? Because some things can be novel but not inventive, as we have discussed in case of cradle. It was novel when painted yellow, but it was not inventive. The next slide. An invention that is the product of patient experimentation or that is discovered entirely by accident is just as patentable as that arises from pure mental effort. So that is something very common, that okay, whether you have put in so much effort or whether you have come up with that invention accidentally, so it will get you the same benefits. Both will be considered equal from the examiner's eyes. Thus, we can also say that patentability is not affected by the manner in which the invention is made. Okay, so irrespective of all the efforts you have put in, if the invention is worth, the invention has an industrial applicability, it has an inventive step, is novel, then only you will be given the protection. The next slide. So this is the requirement of patentability. The last requirement is capable of industrial application or industrial applicability. The first two we have already discussed. Examination criteria is novelty and inventive step. The last one is industrial applicability. I mentioned it in the beginning only that the invention is to be worked. It is to be manufactured. It is to be worked by the patentee. If it is not being worked, then they might take the patent back from them, or might issue a license to someone else. So that's why it should have some industrial application. Fine. It should be of use to the industry. It should not be a waste invention which is of no use, but it should be useful one. Fine. The next slide. Now there are certain inventions which are not patentable. Actually, Section 3 of the Patents Act, it deals with inventions which are not patentable. But I will just discuss few main points with you. The first one is which is frivolous or which claims anything obviously contrary to well-established natural laws. You can see this clock. So can you see something different in that? Yeah. It shows 15 hours. So this is something which is contrary to the well-established natural laws. And such things cannot be patented. Manya, I think I have lost the slide. Okay, okay, sure. So the first thing which is contrary to well-established laws of nature. Find the clock showing 15 hours. The next is invention. The primary or intended use, I mean, the invention which, when used, would be contrary to public order, morality, which causes serious prejudice to man, animal, or plant life or health or to the environment. Let's say that the Tesla car emits harmful radiations and it is prejudiced to the environment. So that way it won't be patented. Okay. The next one is mere discovery of a new form. So it says that something which is already known in the art, and you have just discovered a new form of it or a new use of it. So we know turmeric, certain uses of turmeric we already know, the antiseptic properties and all. So we know that it is used for wounds, for healing the wounds, for blood purification. Now someone discovers a totally I'll say that entirely a different application of turmeric, that maybe it is used for what do you say, I don't know, a different application. So maybe when someone has discovered an entirely different application of turmeric, that won't be patented because that is already known to the art. You have just discovered a new application. So it won't be patented. There needs to be an entirely a different invention itself. Fine. The next slide. Your Tesla car has a windmill installed. Okay, this is regarding 3F, mere arrangement or duplication of known devices. So the car has a windmill installed. Now, this also cannot be patented because the car is known, the windmill is known. The car and the windmill, they are performing their basic functions only, which they are supposed to perform. The car is performing its own function, windmill is performing its own function. We have just combined it, arranged it. So this mere arrangement will not be patented until and unless it is creating a different effect. It is bringing out something, some effects which are not obvious. Fine. But in this case, it is very obvious. Like we are combining a fan and a tube light together. They are performing their respective functions only. So this is a mere arrangement and it is not bringing out some unusual or non-obvious effect. So that won't be patented. The next slide. Yes, the kinds of specification, the kinds of application I said. There are two kinds of application based on the specification part. Specification is the description of the invention. First one is the provisional, second is the complete. Next slide. So advantages of provisional. I will just give you a brief introduction about both these specifications. So provisional is the one when you file an application, it is not still in its complete form. So you file it with as much information as you have. You file it, and then you get a window open for 12 months. Within 12 months, you need to complete the application, and within those 12 months, you need to file the complete application or complete specification. Now we will understand that why is this provisional application filed? Can't we just come straight away file the complete one? Why? First is priority for invention. So I'm working on some invention and I feel that maybe this is the need of the hour, and many other companies, many other inventors, they are working on the same field or the same invention. And I'm scared that they might complete their work before me, and then they might file it. Once they file it, then my invention would be of no use. I won't be given a patent because their application will create a prior art for my application. So, in that case, what I'll do, I will take a priority over them. I will file a provisional application which has as much information as I have. And then I'll have 12 months with me. I'll complete my invention and I'll file a complete one after 12 months. Within that 12 months, by the end of 12 months, fine. So what happens is, because I have already created a priority, Let's say I have filed the one on 1st January 2023. I filed a complete provisional specification. My competitor, he comes up, he files the complete one on 1st February. In that case, I will be given priority because I have already given certain information to the examiner. I have already filed an application. So this priority is the one. Next is get extra time for further developments because I'm getting extra 12 months for completing my invention. Also, not for the developments, but to obtain financial support. So once I file the provisional, the rest of the process is not started. Fine. I'm not paying for examination, I'm not paying for other formalities. It's just that I have filed my application, I have told that okay, I'm working on this invention. Please get this on my name, and I'm giving you a provisional application. Now I have 12 months. So within 12 months, I can look for other financial supports, I can look for investors, I can look for other companies who would be interested in taking up my invention. So I get that extra window of 12 months. In case I find out that okay, this invention is not of use to the industry, no one is interested in the invention, I can drop that there only within those 12 months. I will not continue that. So it gives you a window for forming your strategy also, and then explore commercial feasibility as we have discussed. Whether it is commercially feasible or not, should I drop it here only or should I continue with other processes? Right. So that is why a provisional specification is filed. The next slide. When can the complete specification be filed? After a provisional specification, it should be filed, and within 12 months from the provisional. And yes, the complete one is essential for grant. So you cannot proceed further with the provisional. Provisional is just for giving you an extra 12 months window so that you can complete your work, you can get financial support, you can check the commercial feasibility of the invention, and then you can come up with the complete one. But the process for grant will follow only after the complete specification is filed. At the first instance, expedites grant of a patent. So if you file the complete specification first, like you are not going for a provisional one, you directly file the complete one. Obviously, the process of grant is expedited because that 12-month is deducted from that whole process. Fine. So it totally depends on where you are, at what stage you are in the invention, what risk you encounter from the industry. The next slide. Complete specification. So these are all the titles you need to fill up in the complete specification. The preamble, it describes the nature of the invention and the manner in which it is to be formed. So there should be a title of the invention, the field of the invention. So write down the title, write down the field, the background. Background means the prior arts which are available. That um, okay, my title of invention is this, my field is this, and this A technology is already available, B technology is already available. However, there are certain problems with the prior art, or maybe there is still a need of certain advancements which my invention is bringing up that you need to explain. So, what is the object of your invention? Then a summary, then detailed description, claims. We already discussed that this is the most important part of your invention. Whatever you write down in the claim, you are entitled to have a protection only over that part, only over those features, and not anything else described in the description. Then the drawings to support the description, to explain it in a better way, and then there is an abstract. So these are all the titles you need to cover in the complete specification. However, for a provisional, there is no format as such. You just need to incorporate as much information as you have at that moment of filing the provisional. The next slide. The next slide, please. Okay, so the last topic is how to be a patent agent or patent agent registration process. No, I think we have one more topic left, the filing process. Okay, so statutory requirements is you should be a citizen of India, have completed the age of 21 years, then have obtained a degree in science, engineering, or technology from any university established under law for the time being in force in the territory of India. Also, the final year students here can also appear for the examination. So once they clear the exam, then they have to wait for their degree documents. So once they submit the final degree documents, then they will be issued a certificate, patent agent certificate. But yes, they can appear in the examination in their final year. Have passed the qualifying exam prescribed for the purpose. The qualifying exam is the patent agent exam. So all these are the requirements to be a patent agent in India. And once you become a patent agent, you are entitled to attend the proceedings at the patent office before the controllers and to represent your clients or your applicants before them. So this is all related to the patent agent registration. The next slide, please. This is the last topic, which is Indian patent filing process. So first, you have worked on your invention. Now you feel that okay, it is at the stage of filing. Now you get it filed. Filed maybe as provisional or complete. So the rest of the process will be performed only once you file the complete specification. We already know the format of complete specification. Now we have filed the complete specification. After that, it is published. The patent office publishes it after a certain time, 18 months. And if you want to expedite it, then you need to file a request for early publication. Then it is filed within 1 to 3 months. So it is published. By publication, we means it is published in the patent journal. So it is open to public. They are saying that an application has come, someone has said that they have come up with some invention, and now we are publishing it. Now it's open for the public to oppose it. If someone feels that this is infringing their own patent or this is something not new, there are certain defects, then it is open to the public to object. Then after that, you have to file a request for search and examination. So the examiner examines it and issues an examination report. We have already gone through the basic patentability criteria which the examiner considers. Apart from that basic patentability criteria, there are some formal requirements which they need to care of. So based on that, an examination report is issued. Now, from the issuance, 6 months from the issuance of that examination report, the patentee is required to file a response to the report. So they need to address all the objections which are there within 6 months. After that, it is again examined based on the basis of your arguments, on the basis of your response. So after again examining, if it is found that it is okay, now it is in good form, so it is granted and the certificate is issued. If it is not found in the order, then again a subsequent examination is run, subsequent examination report is issued, or proceedings, oral proceedings, the hearing is issued. So after that hearing, if it is found in order, then it is granted or it may be rejected also. And accordingly, a patent certificate is issued. Now, after the certificate is issued, you need to also take care of the renewal. The patent needs to be renewed. There is a renewal fees which is paid. Once it is issued, then a window is open for 1 year for post grant opposition. Till 1 year, anyone can oppose the patent. Okay. And then the opposition proceedings are initiated with that. The next slide. This is again the procedure along with some formalities. So, filing. Along with filing, there should be a Form 1. Form 1 is the application form. Form 2 is the specification. Form 3 is the detail, foreign filing detail. So, you need to tell the patent office when you are filing that I am filing this application, and you need to tell them that where else you have filed it or you are filing it, what all other applications have filed it, whether I have filed it in any other country, whether I have filed a PCT application, in what all countries I have filed it. I need to inform the patent office about that in Form 3. Form 5 is from the inventor, that okay, we are the inventors and we are fine with filing. Form 26 is power of attorney. Power of attorney. So if you are filing through an agent, a patent agent, so you need to give some authority to that agent. That is Form 26. And then Form 28, if it is a startup, SME, educational institute, some research institute. So because they are given certain benefits, startup, SME, educational institutes, they are given certain benefits in regarding fee, regarding process, some privileges are there. So if you want to claim that, then you need to file that Form 28 also. So after filing, it is published. Automatically, it is published by the patent office after certain time. And I said that if you need early publication, you need to file Form 9. Then is request for examination. Within 48 months from the filing, you need to file request for examination on Form 18 or 18A. 18A is for expedited examination. Then the examination report is issued, which is FER, first examination report. Then you need to respond to the FER within 6 months, which is response to FER. Now, after you have responded, if it is complied with the requirements, then it is granted. If no, then it is refused. Also, they can again issue a subsequent examination report or a hearing notice, grant or refuse. After grant, it is published. So after grant publication, I said that it is again in the patent journal and it is published because again it is open for 1 year for anyone else to oppose it. Fine. And then always you need to pay annuity fee, as I said, renewal fees, annuity fee in case of patents. So this is the whole process of filing. Manu, can you check, is there any other slide left? Okay, this is patent agent qualifying exam. The exam is a three-part test. The first one is objective type. So there are questions related to patent practice, the patent manual, the patent act. All these questions are there. Okay, there are two slides. Fine. So there is a first paper which is maybe of 2 hours, yeah, and there are objective type questions in that. So it is 100 marks question paper. And then the second paper, it is also conducted usually on the same day. And the second is regarding drafting and subjective questions. So you are given certain problems, and then you have to draft a complete specification or a provisional specification or just claims based on that problem. So they check your drafting skills. And also there are some subjective questions, descriptive, interpretative type questions. Yeah. So then only you will be called for Viva. And in total, the Viva is of 50 marks. So in total, one needs to have 150, including all three papers. One need to have 150 to be qualified as a patent agent. The last slide, please, Mane. What is that? Yeah. After qualifying, professionals can start practicing as patent agent and help the corporates, as I said, that once you are qualified patent agent, then you can represent your applicants before the patent office, before the controllers, and you can help them get the patents and follow all the procedures. So this is all about the agendas that we had to discuss today. So the window is all open for any questions related to what we have discussed. Mangalam Sharma, can we obtain a patent on my invention without disclosing the important aspects of invention? No, because we discussed that this is a basic object of the invention. So this is two-way process. They are giving you a patent, fine. They are giving you certain acknowledgement, certain monetary benefits, certain credits. But in turn, what the government needs is you should give that invention to them. For 20 years, you will get the benefits, and after 20 years, it is for public. So this is a two-way process, fine. They are giving you certain benefits for 20 years, and you are giving an invention to the industry. So you can never obtain a patent without disclosing the important aspects. It is a basic requirement. Any other question?
I don't think, ma'am, we have any further questions. So
Okay,
I
okay,
would
right.
so I would like to conclude the session. I would like to thank ma'am for this informative and wonderful session, to all the attendees for patiently listening on this Sunday afternoon. So thank you everyone for joining in. Thank you, ma'am. We couldn't have a better speaker for this session. Thank you so much.
Thank you
So
so much. It was too great to connect to all of you. So thank you.
thank you everyone.